this Wednesday morning, April 2nd. So we're going to get a walkthrough of the miscellaneous judiciary bill, S-109, started in the Senate. We're going to hear what we have in the bill, and we'll have some testimony this afternoon. We're going to take on this, and then we'll probably look at various things that we will be putting into it, but that's probably not until later. But we want to kind of get this started and start looking at what else we're going to add. So when do we usually try to send it back so they have a little bit more time, right? Is that what kind of timing usually, if you could remind me?
Eric Fitzpatrick with the Office of Legislative Counsel. And yeah, I think that usually there's some cushion in there because you might end up having things that you yourself want to add second time around. So sometimes that happens. So usually you it's hard to say when there's a moving adjournment date, which no one's quite sure of, but you try and give it, I think, a couple of weeks so that there's a couple of weeks cushion. They can go down there. Maybe they want to add things or take things away, may come back up here, may not. So yeah, I think you want to, generally speaking, what's done is that there's a couple weeks or so at least provided toward the end of the session to allow for the bill moving back and forth a couple of times and changes to be made.
All right, so over to you for a walkthrough of what we have so far.
Yes, thank you. So yes, as the chair mentioned, this is the annual miscellaneous judiciary bill. As everyone may remember, this is a common type of bill in a number of different legislative committees. This is the miscellaneous judiciary bill, but there's also miscellaneous education, miscellaneous motor vehicles, miscellaneous tax, et cetera. A number of different committees have these miscellaneous bills. The idea is that it includes a variety of different pieces, different subject matters that may be purely technical, maybe sort of minor enough not to really warrant their own bills. And sometimes they may just be that another small bill got folded into this one, which has happened already. So I'll mention that as I do my walkthrough. So sometimes that happens. It's sort of a variety of things. I think that most commonly, though, that there seems to be a general attempt to not have anything be in these bills that are subject to much disagreement. Even if some of them may be more policy related than technical, they tend to be minor and that folks have been trying to kind of get on board with. Not just in the legislature, but also you'll find from people who are asking for them as well. And as I do my walkthrough, I'll mention many of these, not all, but many of the pieces in here have been specifically requested by certain of the common cast of characters that you'll see in here. And I'll mention who those are. It will happen during the summer. I'll be sitting in my office. And now that I sort of have been known as the legislative attorney who deals with this bill, I'll get emails during the summer saying, does this look like it could be something that could be added to the miscellaneous bill? And the bills, it rotates every year where it starts. As the chair mentioned, this year it started in the Senate. Last year it started up here. So when I get that email, I'll forward it along to the chair wherever the bill is starting. I'll say, hey, what do you think of this? Should I put it in the miscellaneous bill? Do you want to do it as a separate bill? And feedback. And that's sort of how the file gets built up with stuff that's going to go in it. But, and then our office as well, I mentioned a couple of these. We also, while you guys are gone in the summer, one of the things we do is produce those green books you see on the wall behind you, and we work with our publisher, Lexis, down in Virginia to do that. And while we are reviewing all the statutes that are passed every year, we read them all through a couple of times, as do they, and we'll spot little technical mistakes or oversights. I know it's hard to believe, but that's all we went through during the session that people still find. I know it's hard. Yeah, I didn't make it. Never mind. Some of the other, Actually, it's funny. That'll be even funnier when we get to a mistake that I allegedly made in this bill.
Is that why we have certain people in this room that go constantly grab those books to go and look for errors that you make?
When you say you mean me personally?
No, I wasn't looking at you. I was actually sending it a direct thing to somebody else.
Oh, okay.
I was using you as
I have often read those green books. Wondered who wrote what I was reading.
Right. Well, I'll mention one of those.
Legislative.
You'll see one shortly as we do the walkthrough of the bill. I might even remind folks of a bill that you worked on just a couple of years ago. Anyway, so that's kind of the background. Now I'll segue right into the walkthrough of the different pieces that you haven't so far in the bill as passed the Senate and where they each came from. So the first one came from Willa Farrow, the Community Justice Director of the Attorney General's Office, just asking for some clarifying language for the diversion program. You'll see it in lines 8 and 14, not changing anything substantively, just arguably already there in statute, but just clarifying the terms to make it clear that the diversion is available in all counties just by adding the word available. And also the terminology that the diversion program uses for their clients is person referred to the program, not responsible party. So language change to be consistent with what they do. Over on page 2, line 10, just some stray language. Don't know where those 2 words came from. Obviously not part of that sentence. So they're struck. Stray, a couple of stray words. Section 2, this is a request from the judiciary, from the court. This is a clarification that under current law and currently, the legislature has the authority to set the number of superior judges. That's a legislative responsibility. You guys can do that, and you do that when it changes. And it's changed many times over the years. Right now, if you see line 14, right now there's 34 of them. But every time that number changes, you have to go in and change the statute. So the judiciary has suggested, and that's what's in here, is let's just change the statute so that you say generally, the legislature has the authority to set the number, and that's when it's going to be whatever you set it as. And when you change the number next time, you don't have to go back in and change that number. Just reflects that you have the authority to make that number, whatever you choose to make it. That's that. Over on section 3, top of page 3, actually the next few sections were 3, 4, and 5. Yes, were also all requested by the judiciary, requested by the court, and they all have, these 3 all have to do with the Judicial Bureau statute. Remember, if there's a civil offense as opposed to a criminal offense, it goes to the Judicial Bureau. And the way the Judicial Bureau statute is set up, we define their jurisdiction very expressly, and there's a list of, I think it's in the mid-30s now, 35, 36, 37, something like that, different statutory violations that are civil, and they go to the Judicial Bureau rather than to the Criminal Division of Superior Court. This is just clarifying one of those statutes on the list. It's line 8, that the possession of tobacco products by people under 21 is a civil offense. It goes to Judicial Bureau, not a criminal offense. But that offense is not just possessing the tobacco, it's procuring. So in other words, not just that you have it, but say you went to the store and tried to buy it, you're under 21. So that's also civil offense.
If we have clarifying questions, do you want us to do it now? Sorry, can you just go back to the last one for the judges?
Yeah.
So I heard how you explained it,
Mm-hmm.
but then reading what's stricken. So it seems like it's laying out here that there should be 34.
Right.
So that's not the law.
No, the law is that the number is determined by the General Assembly, and right now that number is 34.
Where in that law is not where, what is that? I guess what's that site? That's not here, right?
Oh, right, that's in the budget. The budget sets the number, the big bill.
Okay.
By appropriating amount for the number of judges they have. As far as I know.
Yeah.
We don't need to have an actual number here.
How long has that number been there?
I don't know.
Huh.
We added a bunch.
Yeah, I mean.
Yeah, I think last year, actually.
Has it changed every time? They just like change it from 32 to 34 to.
I don't know that they do.
Oh, so maybe.
So are there 34 right now?
Yes, I believe so.
Okay, all right, so yeah, they do change this every time.
But I think I remember the number changing a few times over the years.
Yeah.
Especially in the last few years, it's gone up quite, pretty regular.
So this was kind of like a way to formally put in the number of judges based on the budget appropriation.
Yeah, I think that's the effect of it. I think the intent is not to have to go back and change the statute every time the number changes. But I think Judge Zoner is on your witness list. So if you.
No, I'm not. I don't want to get any more into it. I was just trying to understand. I was just trying to understand where it was said, how many, and that seriously in the budget process that.
Right.
Okay.
Yep. So over on page 3, this is another piece related to the Judicial Bureau. This is section 4. This is just clarifying that the current language says it twice, actually, line 13 and line 17. that the law enforcement officer in a Judiciary Bureau case can void the complaint. They can void or amend it at the discretion of the officer. And the court wanted to make clear that, well, that doesn't just mean that there's sort of a blanket authority to void any complaint by the law enforcement officer. They can only do, if there were some other law that said, that put some limitations on what the officer could do, then that would apply. So it's just clarifying that it's, unless otherwise provided by law, then the law enforcement officer can void or amend the complaint. Next page, page 4, again, just section 5, it's also related to the Judicial Bureau, and this is also related to that using a false ID to buy tobacco products, clarifying that it's a civil offense. You see line 4, it incorrectly uses the word fine. That's a criminal term. Fine, if there's a fine, it's a criminal fine. The language that we use for a Judicial Bureau offense is civil penalty. So not sure why that language goes around that way, but for some reason it was, so it's corrected. The next provision is an interesting one. This was requested by the Vermont Bar Association, and it has to do with interesting. If you look at subsection A there, it's the existing law other than the capitalization of the word internet. That dates from 2007. And in 2007, when the court was first starting to put court records online, you think of it, it's only, what, 18 years or so ago, but things were very different back then in terms of online access of court records of anything being available online compared to where they were now. And I happen to remember this because I remember why this language was put in there. And people were very concerned about, oh, we can't have people just being able to sit at home and look at court records. Didn't anticipate things would change as time went on. And so now the situation this is trying to address is because of the way that's phrased, attorneys who are representing clients who might want to see criminal, family, or probate case records that are relevant to the case from their office can't do it. They have to go down to the courthouse, to the terminal at the courthouse, to the public access terminal, to look at any case records and criminal, family, or probate case records anyway, that they might be thinking are relevant to a case that they have. So this has been a concern expressed by several attorneys and the Bar Association, and the court worked with the court to come up with this language. And the idea is that you'll see it starts in line 14, that the court is required to provide licensed Vermont attorneys in good standing with access via the internet to non-confidential, not just any records, to non-confidential family and probate court case records. So it provides a method for attorneys to work remotely, essentially,
So
rather than having to travel down to the courthouse.
how does the system pick up whether the attorney is in good standing?
Yes, it's interesting. The court testified about that downstairs, and evidently they have a system for that. So, and I think they already use it for something else. I can't recall what it is. But anyway, it's not that they would have to create it for this. They have it, and they said it would fold in pretty easily.
I would imagine they need to know who's appropriate before then when they're testifying or practicing law in the courtroom.
Yeah, there must be some way for them to know that you're not subject to a professional conduct complaint or in some other way that they're not in good standing. So they have it.
Huh. Yeah.
Another good question for the specifics of that, though, when Jozonia or Terry or both are here.
And we don't capitalize internet?
Yeah, that's interesting. I defer to our editorial staff on that because it used to be capitalized. And then when I used a lowercase I, it would come back with a capital. I didn't ask then either. And some
It's not a proper name. Doesn't need a capital.
It doesn't.
really?
Internet,
Just the internet.
the interest.
It's the name for something, right?
Yes,
There's
but
only one.
Right, there's only one.
who owns it? Like there,
Yeah.
it's become
Sudden
something
vague.
different.
I can see like if it were tissue, you wouldn't capitalize tissue, but Kleenex, you would capitalize.
Yes, brand name.
Right. But to me, that's more like
Internet.
Kleenex internet, right? Right.
Feels like a proper.
Tissue.
Tissue.
Internet is now a tissue.
Who are we calling in on that one?
Oh my God, we should move on.
Okay, great, yeah.
That's rhetoric expert.
Yeah.
In the sky.
Yeah, that's a really good question. I'd like to hear the question.
Write down and on this one. We need a lot of testimony on
We're
whether
totally
capitalized
losing
internet.
control over a small or a large eye.
Important detail.
And it's still unresolved, right? Well, not in the editorial, and not in the editorial
In
staff.
my mind.
Oh, that's
It'll
right.
be in about 10 more seconds.
Copy editors all around the world agree.
All right, that's fine. Like I said, I defer.
I'll text the expert right now.
All right, sounds good. All right, so moving on to page 5, section 7. All right, this has to do with attorney's fees in mortgage foreclosure actions. The general rule, there's a general rule that's in the Vermont Rules of Civil Procedure that says that when attorney's fees are asked for, if the amount of the fee that's requested is less than 2% of the judgment, you don't have to have a hearing. Court can just rule on the papers. You don't have to actually have a hearing about it. But this section of law, which has to do with mortgage foreclosure action specifically, seems to require a hearing in all cases, regardless of the amount of attorney's fees requested for. So this is something that the court asked for, said to make it consistent with the rule, rather than requiring the court to have a hearing in all cases where there's an attorney's fees request, strike the words upon hearing, and then it'll be covered by the general rule in the Rules of Civil Procedure, which is you only have to have a hearing if the amount requested is 2% or more of the judgment. All right. Sections 8 and 9. This is one of what I mentioned earlier, that sometimes a bill will get folded into the miscellaneous bill. This is such a bill. S61 is where it is. Maybe a House bill too. I'm not sure. It may be a House bill, but this has to do with switchblade knives. And the issue here is that current law prohibits both zip guns and switchblade knives. I'm pausing for the question that usually comes up here.
What's a zip?
Yeah, you got it. What's a zip gun?
Piece of pipe, a bullet and a hammer.
There you go.
Wait, piece of pipe with bullet and hammer.
Yep. It's a
Pretty
non,
much.
right. It's a non-registered firearm, usually made from parts stripped from other devices or firearms. For example,
Ghost gun, is that what it is?
Piece of pipe.
Sounds like.
no, it's not necessarily made by a 3D printer or anything like that.
No,
It's like you take a couple of pieces.
Serialized, not serialized.
No, not serialized, but it doesn't fit the definition of a ghost gun because it doesn't have the 3D.
You can go
A
in.
receiver or a,
Nope.
yeah, so
You just
that's where.
Pop a couple pieces. Oh, right.
Yeah, that would probably be why.
Kids in prison.
Yeah, so kids in prison, so, all right.
But this doesn't change the zip gun portion of the statute. It only strikes the switchblade knives portion. And the reason for that is that my understanding is that people who have automatic opening knives, see, switchblade here does not have a definition. So there's no clarity as to what a switchblade knife is. So if you have, and it's pretty common to have an automatic opening knife, a knife that has a little button on it that you press the button and the blade pops out. And some people who have a relatively common device, these automatic opening knives, could technically be violating this criminal statute by possessing them. So the approach that S61 takes, and now that was folded into the miscellaneous bill, so just strike the prohibition against switchblade knives. And we checked with the court, and you'll see the next section has to do with expungement of criminal history records. So if you've been, since the proposal is to strike switchblade knives crime, then this is something that you may recall is that I think has been an approach that has been taken in other areas. For example, the marijuana possession was the first one where it said, when a crime is repealed, often it is tried to expunge prior convictions for that crime. The idea being, well, if we're going to repeal the crime now, why should someone's prior convictions still be on the books?
Has anybody been convicted of it?
Actually, 10 people since 2000. The judiciary, we asked the judiciary to look into this. There have been 10 violations in the last, 25
Was
years?
that the deal they made? I couldn't have started it. Switchblade one. Really?
Oh, I don't know. That's a good question.
I was gonna say, what?
Okay.
Yeah, they had 10 on the books, but they said it'd be no problem for them to expunge them. And then we also asked, well, can you tell were the convictions for zip guns or switchblade knives? Because the statute was phrased as both. And they said they did go back and they were all switchblade knives.
So in that wasn't section 9, it wasn't actually part of S61, was it?
Correct.
So they added that.
Yes, good catch.
Because they were having fun with sealing and expunging. So, so, well, actually, I'm curious about that because it says it's going to be expunged and we have this S12, which is moving everything to sealing. So, So if we pass S12, which we intend to do, and go to a ceiling, should we take this part out or should we just kind of flag to change it to ceiling?
I don't know much about S12, so I guess I would say I don't know the answer to that.
Are we
I'd
allowed to
suggest,
talk about that now?
Yeah, we have the bill. Yeah, we have a bill in committee that we were not allowed to say expungement until we had a bill from Senate.
oh, right.
And so now we have the bill, so we're allowed,
I didn't know that.
ban has been lifted.
Right. Well, I would suggest, since the court is very familiar with this language and looked into their ability to expunge it, when they come in to testify in this bill, ask them that question. See, should it be changed? What's the difference?
I would see it, the law is being vacated, then I would think the record would be with it.
I
mean, if,
we're trying to move to all just.
yeah, I know.
So,
One procedure question. You may have covered this because I came in a minute late. If we look at something and we're like, well, this is kind of policy, we should probably like talk about this more, and we pull it out, then can it still be like considered and passed?
Well, we wouldn't-
Came out of the Senate, or
no,
does it?
this can have policy. So, yeah, we just try to make, I think traditionally we've only put stuff in the miscellaneous bill that we have unanimous agreement.
Yeah,
And that's not like a 40-page ceiling bill. We wouldn't put that in. But it's used to be technical changes, but that has changed over the last number of years.
okay.
But we will hear testimony.
Yeah, but we're gonna get testimony on all this. Yeah.
Okay, cool.
I'm marking down folks that I want.
And I'm not saying that about the switchblade thing. I was just sort of curious. Yeah, okay.
And we'll bring Pat Brennan to testify.
I think he was a sponsor.
Yeah, and Dan Noyes on the companion bill,
Right.
which was H 350. So,
Ah, right.
but anyways.
Yeah, so that's the switchblade knife issue. Over on page 6, section 10, this section was requested by the Victims' Compensation Board. So Victims' Compensation Board awards compensation to crime victims who suffer a pecuniary loss as a direct result of a crime.
So is that Jen Pullman or who's?
I thought I know she said, I'm not sure who the head of the board was. I thought that Bob Paley might have been chair of the board.
Okay.
But it could also be someone like Jen, who's the Center for Crime Victim Services. So
Right.
might be worth checking in with both of them.
Okay.
Yeah. So the board awards compensation to crime victims. They also can award, if you look at lines 8 through 10, not only to the victim, to an intervener, someone who was injured or killed in an attempt to assist a crime victim. When it's a crime victim, they can get compensation for both physical and emotional harm. My understanding is the board has found that they've been seeing a lot of applicants for compensation from interveners who are alleging that they've suffered only emotional harm from perhaps more of a bystander situation where someone not necessarily being involved in the crime as much as they were sort of envisioning in an intervener situation. So they want to limit it somewhat and say that if it's an intervener, as opposed to the victim themselves, it has to be a physical injury for them to get compensated, as opposed to an emotional. So that's the proposal there. Section 11 starts bottom page 6 over top page 7. This is purely technical. This is something that our office found during the rewrite of the statutes we do every year that I mentioned earlier. It's just a stray subheading over on line 1, page 7. So it just strikes a subheading that's not necessary. Now I think section 12 is the language that you guys just passed in S9. This is the same language because it was originally in the miscellaneous bill as well. This has to do with relief from abuse orders and making this is for the stalking orders, but it's making the process for service of a stalking order the same as you made it for relief from abuse orders a couple of years ago. Actually, it was done in the miscellaneous bill in 2023. That's the idea that if you're sitting there in court, remember, if you're the defendant and you're sitting there in court during the relief from the RFA hearing, and you're there when the court issues the order, then the sheriff doesn't also have to go out and personally serve you, providing the order to you at that time. satisfies it, and then it can be mailed to you later on. So this makes the stocking orders the same. So does that ring a bell? Am I right that you just passed, that was an S9?
Just passed it yesterday, so,
That was the amendment we put in our.
yeah, it was the amendment, we moved it over to there from here. And my question is, depending on timing, presumably that one might make it all the way through to law before this is ever passed. Would we then take this out?
Yes.
But if it's still kind of out there, does it hurt having it the same exact language in two places?
No, we do that sometimes.
Okay.
Because if you're, it's always one of those, you want to make sure it gets passed and it still hasn't happened yet. Can sometimes, I just spoke to Michelle about that before I came in, just asked her that exact same question, just to make sure, because that's the way I remembered it as well, what you described. But if you're right, if it's already passed and signed, then no reason to have it here again.
It would take out. Okay. Like that.
Yes.
Ken has a question.
But if I remember right, going back probably 2 years ago, the clerk shall mail a copy of this order to the defendant at the defendant's last known address. Didn't we have a lot of chat about that, where a lot of times they weren't their last known address, we couldn't find them, they had no notification, so it was, lack of better words, an excuse not to show up and all that stuff. Where did we arrive anywhere that actually safeguarded us a little bit better?
Yeah,
Yes.
I think in this case, where you landed was, it would be okay in this case, because in this case, it's required under lines 11 and 12. This only, the mailing only counts if the defendant was sitting there in court and handed a copy of the order in the first place.
Right.
They've already got it. So if they happen to not be at that address, you don't have to worry about the fact that they never got it, because they were handed it when they were in court. So that's, I think, where you landed on this, that you're right about the concern generally. But in this case, it was going to be okay because they already had the order.
So it would, is it legal to have an email or a text a notice too? Is that?
I think, the way, at least sort of when you're notifying somebody of court proceedings, that it's generally permitted to provide what works. A lot of times personal they have to, someone can't be the subject of, denial of due process without at least having notice of the proceedings and reasonable good faith effort to provide them that notice. But these days, there may be other methods of notice that would work, as you just described.
Am I messing this up?
Yes. Yeah. Tom's reporting this bill tomorrow. That
I
has.
do have a question.
You can talk to Tom Oliver about whether.
I do have a question.
Okay, Tom. Well,
If you're handed it in court, is it indicated that they're served in a return of service?
Not service books.
I don't know,
Huh? By who? By the court,
right?
Like the judge.
It does say on the
or the
record.
clerk that handed it to
It's on
them?
the, yeah, it's a record.
It wouldn't be, well,
Yeah, well, no, it says on the record, lines 11 and
it
12.
has to be on the record.
Yeah.
Yeah.
Defendant notified
But I
by the
don't see
court
them
on the
getting it until
record.
they go to the window, but
Yeah, no, you might be right, because it does say notified by the court on the record.
yeah.
And actually says the line before.
How does it really work and what does it say and how does it really work? That's all I'm trying to figure out.
Right.
Oh, you're reporting tomorrow, Tom. I hope you.
I'll make sure to ask you about it on the floor.
No, seriously, where are we going with this? Didn't we take a lot of testimony on this where they are skirting the system on that?
No.
That's because you don't want to deal with it.
No, because we took a lot of testimony and decided that it's perfectly fine if they're in court, they're notified of what's required in the order, and they actually get the order at the court, that we don't have to actually serve it, but in fact, I'm not sure. There was a reason why we still nevertheless said, but we'll still mail it as well.
Right.
That would be the question, is why did we decide that they would
You to mail it.
still mail it anyway? But we did back then when we dealt with this for RFAs, for relief from abuse orders.
I'll sleep on it.
Okay,
I think it's got more than enough.
there's more than enough due process.
You're comfortable with that?
Oh, more than. Oh, if it's coming from two sources, yeah, I mean,
Okay,
they're mailing it and handing it to you, what more do you need?
All right, if you're, I mean, this is your job, so.
Yeah.
Just as long as you do your job.
So were you not comfortable that I was comfortable with it, Ken?
No, I don't trust you.
Oh, okay.
No, you're my favorite bill.
Oh, law enforcement, okay.
Thank you for your service, Representative.
You know what we talk about.
Oh, that's a good one. Okay, I like that.
Okay, so moving on.
Yes, moving on. Next one, purely technical, also noticed by our office, just an incorrect cross-reference. See that over top of page 8, line 1, correcting that cross-reference, which isn't quite right. The next one, section 14. This was also a request from the judiciary, from the court, I believe, and from the probate judges, actually. Because this has to do with petitions for guardianship. And right now, under the existing law, lines 8 through 10, when someone files a petition for a guardianship and it's denied, the court has to, you'll see line 10, dismiss the petition and seal the records. So they file a petition for guardianship, they deny it, they dismiss it, seal the records. So this adds a provision that says, well, it basically requires the same result when the petition is withdrawn. So if somebody files a petition, in fact, they withdraw it before the end, well, in that case too, dismiss the petition, seal the records. Same result.
Well, that's common sense, right?
I think it makes sense, absolutely. I don't know why it wasn't that way before, maybe it was just an oversight, possibly. Speaking of oversights, section 15, starting on page 19. This is the Uniform Power of Attorney Act that you passed in 2023. You may recall that it had an optional power of attorney form in it, which had some corrections that you made in the miscellaneous bill last year. So as found in this case by Lexis during the review process I mentioned over the summer, there was another error. This is an interesting one. You look over on page 10, you'll see if you look at lines, and so this list here is a list of things that can be in the optional form I mentioned. And the person is filling out their power of attorney form, but they want their person they are designated as their power of attorney to have any one of these authorities, they can check the box. Hey, if I want the power of attorney to be able to do this, I'll check that box. If I want to do that, I'll check that box. So one of the ones that they can have their proposed the power of attorney act on behalf of their behalf is line 3, consent to the modification or termination of a non-charitable irrevocable trust. So they can have, rather than consenting to the trust themselves, they can have their person do it under power of attorney. But if you look at line 7 to 8, they can also have them consent to the modification or termination of a non-charitable irrevocable trust. It's exactly the same language as in lines 3 or 4. Not intended. So
you checked one and not the other?
right, that would be funny.
So Joe Adriano didn't catch this for?
It's funny that you mentioned that. He did email me over the summer with a couple of other suggestions, and we went back and forth on it. And it turned out they were okay. This one he didn't actually catch. No, it's
No, told him and give him some grief for that.
yes. Whoever did miss this was whoever the attorney was who worked on this bill 2 years ago. I don't know who that was, but I'm gonna find out who that was, and I'm gonna confront that person and say, how did this mistake get made? However, the mistake is one quick Joe Andriano tangent though. So last summer I was timing at my daughter's swim meet, and he had to go up to the table at the swim meet, and there's a big list of all the volunteers to get my stopwatch and check my box that I was there, and I saw this Joe Andriano. I was like, wow, I didn't know John had a kid at this swim meet. So I put on my phone and I emailed him, like, Joe, are you here? It was actually the league meet. It's huge. And he emailed me back and he said, no. But believe it or not, there's another Joe Andriano in Chittenden County. And so that must be who it is.
Huh.
All right. Small world.
It's good to know.
Yeah, exactly.
Hey, there,
You know, he said Chittenden County.
there might even be, I think the pair of Joe, that of Chittenden County the wife has the same name as Joe's.
Right. He didn't
Yeah,
know.
I think, because I saw something the other day and I was like, they don't live here. Anyway,
That's
carry on.
Yes. So this corrects that error and adds what was supposed to be in there in the first place, which is allowing the agent to create, amend, or change rights of survivorship. All right, speaking of corrections from bills that were passed recently, over in section 16, page 11, this is the Uniform Directed Trust Act, which you passed last year. Had a typo, you'll see it's in a few places, it's just a grammatical oversight that in several places, the word under has to be in there. You see, as it is in line 10 of page 11, has the correct phraseology, referring to another statute under that statute, and adds that language in section 16. Section 17, also purely technical, an incorrect cross-reference that our office noticed, that's over on page 12, line 5.
I'd love to talk to Joanne Brown about this one as well. Stats.
Oh, the directed trust one?
He was the direct trust person too.
That's right. Yeah.
Bills for many pages long.
Yes, you might want to have him in as a witness too.
When he comes in, he's gonna tell us that he was right about his no vote on the land fraud bill that we will go on.
Right, right.
So anyway, go ahead. So I'm not gonna have Joe in so he can rub my face in it.
Right, right. All right, so section 18, page 12, this was also from Willa Farrell, Community Justice Director at the court. This has to do with basically making the juvenile statute consistent with Act 180 that you passed last year. That was the pre-charge diversion statute. And you remember what the pre-charge diversion statute did basically was that, at least with respect to juvenile proceedings, and over if you look at lines 8 through 12 on page 13, this is adding to the juvenile statute an option for the state's attorney that was in the pre-charge diversion bill that we passed. It was in Act 180 anyway, just adding to, and the state's attorney already has this list of options you see in that existing law that I just pointed you to, of steps that the SA can take other than filing a juvenile charge. So pre-charge, here's these things that the SA can do: Community Justice Center, Balance and Restorative Justice Program. And it just adds to that list pre-charge diversion, which was specifically mentioned in the pre-charge diversion bill. The language, I jotted it down, just the bill said the juvenile diversion program may accept referrals pre-charged by law enforcement or prosecutors where a child or a youth has committed any offense or delinquency. So that's what this is. Just basically trues it up with what was already in Act 12.
Is balanced and restorative justice? Oh, sorry.
All right, I just, the 16 to 19 for the child. Got it.
Yep, you got it. Okay, over on to page 14 through 15, and this is, this has to do with, that's, oh, by the way, this was a request from the Vermont Bar Association property section. And the Vermont Attorneys Title Company, which actually is now known as CATIC. They were, I think there's been a combination of Vermont Attorneys Title and the Connecticut Attorneys Title Company. Now they're just referred to as CATIC, C-A-T-I-C, but it's the Attorneys Title Company in Vermont, working with the VBA property section, has proposed this language. And the idea here is that it has to do with title searches in Vermont. So when property records are searched in Vermont by attorneys or someone working for an attorney's office in order to confirm clean title. So when property is transferred and you want to get title insurance on your property, you have to have somebody verify that you've got clean title. And you have to go through the municipal land records to find that out. As everybody probably knows, municipal land records go back quite a ways, and they can be quite voluminous, and they've been around for a long time. And sometimes there can be gaps or errors in the land record. So what you have on the books now in quite a number of different places is some corrective statutes, some statutes that validate technical errors that are in the land records, that have been in the land records for a long time without being challenged. So those exist in this one section, actually. You see line 2, page 14, the title of that section is Instruments Concerning Real Property Validated. And that lists all these circumstances under which old documents in a chain of title will be validated if they've been sitting there in the land records for a long time and nobody's challenged. The idea is, well, that because otherwise you'd be having a lot of people not being able to get title insurance because of some, old technical error that nobody ever noticed before. So just as an example, I probably put too much in here. I put a few existing provisions in here just so that people could see what some of the existing ones look like. No need to go through all those, but for example, subsection A on page 14, that's an existing one for if for 15 years there's been a defect in a deed because it didn't state, because it wasn't properly witnessed, it wasn't acknowledged properly, or it wasn't validly acknowledged, isn't challenged 15 years, then it's valid. So this proposes to add one more to this list of things that are going to be validated. And the new thing added to the list has to do with powers of attorney. So if the deed says, for example, transferring property, bless you, yes. The deed says it's being transferred from person A to person B, but the person doing the transfer is acting under a power of attorney for somebody else, right? Because, for example, going back to our Uniform Power of Attorney Act, maybe somebody is designated, hey, my power of attorney, I want you to be able to transfer my property for me. I checked that box. So if somebody does that and they transfer on behalf of somebody else, the way the law is written, not only is the deed supposed to be in the land records, but the power of attorney is supposed to be in there too. Because if the deed says, hey, this was executed by A on under a power of attorney for person B, you might actually want to see, well, I want to see that power of attorney then to make sure that the person actually did have the legal authority to act for person B. Well, sometimes that power of attorney is not actually recorded, even though it's supposed to be. Particularly the older you go, the further back you get. Maybe somebody forgot to record it. Who knows what happened? But sometimes it's not recorded when it's supposed to. So what this says is, well, if the deed that says it was signed under a power, it was a person acting under power of attorney is in the land records for over 15 years or more, nobody challenged it, then it's still going to be valid to transfer the property, even if when you go back and look, the power of attorney isn't there. That's the gist of it. Makes sense how that works?
Yes.
So moving on, section 20, this is fairly technical. You may remember that years ago, Judge Zone's position, which is now Chief Superior Judge, used to be called Administrative Judge. And we went through all the statutes and thought we had corrected that title every time it appeared, but every couple of years we find one that we didn't get. So here's one of those, line 17, page 16. Updating the title to what it currently is, Chief Superior, not Administrative. Over on page 17, section 21. This is repealing a reporting requirement. And what it was is back in 2023, the legislature passed this requirement that DMH and Dale, Department of Mental Health and Department of Aging and Independent Living, report on annually, starting in 2025, this year, on the state forensic facility, which was envisioned to be in existence by then. However, it is not. It is not in existence, and reporting on a facility that doesn't exist is really impossible. So this is being repealed. You can always reinstate it if the facility ever actually happens, but it hasn't happened yet. So there's no sense having this in statute. All right. Next section 22 starts on line 7. This is a repeal of the Coordinated Justice Reform Advisory Council. This was established by the legislature in 2023. It is scheduled to be repealed already if you look at line 11, but it's not for another 3 years. In 2028 is when it's supposed to be repealed. Both the chair and the vice chair of this council, which is Judge Zone is the chair, and the vice chair is, she used to work for the Department of Corrections, so I'm forgetting her name.
Monica Weaver?
Yes, thank you very much. Monica Weaver is the vice chair. They testified down in the Senate that that the body is unable to perform one of its primary duties now anyway, because evidently one of the things that the council is supposed to do was to make a recommendation about how, if for the Department of Corrections budget, I think it's like a maximum $900,000 line item in their budget for justice reinvestment. But evidently that amount is now going somewhere else, and they aren't able to make that recommendation. So they said one of our primary functions is no longer something we can do. So it seems to make sense to just repeal it now rather than wait 3 more years. So on the basis of that testimony, that's why this is here. All right, sections 23 and 24 are also repeals. They go together, 23 and 24 on page 17. This has to do with the public inebriate law. This is interesting in that it goes back to 2008 that there was this provision that was placed on the law, placed in the books, and never enacted. It always had this future effective date. And what the provision said was that public inebriates cannot be incarcerated in a DOC facility. Right? That was what it said. And at the time, I think the thought was that there would come a time where they wouldn't need to be incarcerated in a DOC facility because there would be another place for such people to be held if necessary when someone was a risk of harm to themselves or others because of public intoxication. But that never happened. So at least 6 times since 2008, I remember it seemed every couple of years, I would put in either the miscellaneous bill or some other bill. Let's defer that date by another couple of years. Let's do it by another couple of years. It happens quite often, or regularly at least. So rather than do that, this proposal is just repeal that, so that as is the case now, public inebriates would still be when a danger to themselves or others could still be housed temporarily at a DOC facility. And I think this was in H411, the governor's public safety bill.
Page 86 of H4.
Okay, all right, thank you. I'll write that down.
Got that, Ken? Another?
H411?
Yeah.
Was that a bill that, where is that anyway?
It's
On the wall.
Right. Let me see.
Shocking.
It's actually in S12, H2, S109. We're piecemealing. It's in multiple bills.
Don't stick up for him, Oliver.
I'm not.
I should also note that it is also in S36, a human services bill that passed the Senate and is now in House Human Services.
So the same thing.
Same thing.
Okay.
Is there any process to that?
Why it's in both places?
No, any process as to getting a public inebriate to the jail without any other screening? Is there,
There
does
is,
it explain the process?
there is some language, yes, that's in Title 18. I was looking at it about sort of, involving a drug counselor, that sort of thing.
Or the hospital?
Yeah, I think that's it. I don't know the details of it, but I noticed that it was there.
Thank you.
Yeah. All righty, so now we're moving on to, this section 25, the firearm surrender working group. This was requested by the Vermont Network Against Domestic and Sexual Violence, working with the Office of Attorney General. Now, the idea here is to create this working group to study, because there are a number of different places in Vermont law in which firearms can be either surrendered or temporarily taken into custody by law enforcement for various reasons. You think about relief from abuse orders. Someone has a relief from abuse order against them. In statute, the firearm has to be surrendered while the order is in effect. Domestic assault arrests, you guys passed that in here. It has to be surrendered if someone's been arrested for domestic assault. The ERPOs, the extreme risk prevention orders, if someone's a danger to themselves or others through a firearm procedure. So the idea behind this is not to have any effect on what places in current law can or can't require firearm surrender, but is to say, to develop, you see line 4, develop a uniform process to ensure compliance with orders. So the idea is to study what changes are needed to create a uniform process to, this is line 7, monitor compliance, support entities charged with storing these firearms, because that's an issue too. Who's got the room for them? Where are they putting them? And identify a stable and reliable funding source to monitor compliance. So the idea is just to not change any law as to when firearms have to be surrendered, but to look for, is there some kind of uniform process that can support that? And you'll see a long list of people who are supposed to be. So it creates this working group to study that. And says that the Attorney General has to be the one who convenes it, has to include a long list of people that you see, public safety, state police, commissioner of corrections, et cetera, et cetera. And they have to, over on page 19, line 18, they have to file a report with you folks, the Judiciary Committees and Justice Oversight by November 15th of this year. And over on page 20, report has to include a statewide proposed compliance model that will work in the courts, excuse me, and recommendations for any legislative changes necessary to support it.
So just on this one real quick, it's H221 is language that's similar. This is a recommendation from the Fatality Review Commission. And actually just before crossover, I was working actually with the network and with Tom Burdett and others with some slightly different language than this, which I am going to propose as an amendment to this language. We'll hear from Charlie Glisserman this afternoon from the network. So essentially, I'll tell you up front what the proposal is going to be is it's going to significantly reduce the working group And it's gonna then push a lot of people over to a list of entities that need to be consulted with. And you know, I have that language, you know, already that I will get to you for consideration. So,
Great, sounds good, thanks.
but Tom, do you?
Yes,
I see something missing in that list that I think should be on the list. And that would be an advocate for the gun
Yeah, so
or the gun owner.
I've been struggling trying to figure out how to put that in as one of the consultation, and I think even though it may seem odd, but I will propose it and we can have testimony, we can talk about it, of just putting the Sportsman's Federation as one of the entities that needs to be consulted with. Because, I mean, it seems odd for the compliance, but it isn't really, because this is an entity that we always go to when we're seeking testimony on any firearm things, and they have a lot of knowledge there. So that was what I was thinking of doing.
The only reason I bring it up is I was in charge of an evidence locker for a very long time, and it can grow, the pile can grow and get quite cumbersome and out of control. And the other thing is every now and then there's one in there that's worth a real lot of money. And I think I would want somebody to advocate for proper storage.
Yeah. Yeah.
Just because I want to just eat, an accident.
So, and I'm hoping with that addition that everybody will be able to be on board for this. And that's something I'm going to work on soon, because I do want to see if everybody's good with whatever my proposal is going to be. That's why I was also working with Tom, because he had some issues with it I was already trying to solve. Because if we're not all good with it, we're going to take this out and it's probably going to appear in a different vehicle, so that we can disagree with if we need to get there. So just want to give that heads up for folks. So I think that was the end of that, right?
Oh, yeah, right on line. Yeah, that's it. That covers everything.
So just a couple other things real quick, just to also a further heads up. I anticipate that we will be putting H108 language into this bill. H108 is what's it called?
Billion.
The filial support, which we took testimony early this year. And also H7, which I thought the Senate was going to put that in. But apparently I just now see that they didn't. They have a companion bill. I don't remember what their companion bill is. Termination of parental rights in adoption proceeding. This is something that was in last year's miscellaneous bill. Something was taken out at DCF's urging, and then we heard from the private bar that said, why did you take that out? So we wanted to have more testimony on that. But apparently it didn't get done down in the Senate, so we'll probably take it up here. So there's also some language that I had proposed from Judge Zone, which was in response to a bill that I don't remember which bill it was, having to do with guardianship and a task force of the guardianship. I think you have that language.
Yes.
We're still working with Larry Christ and some others on, what's the number on that? 193? H193? Yeah, on H193, it's another task force that, so that might be another thing. Those are the ones that I know of, but there's probably others that I'm missing that have been forwarded to you, Eric, if you can think of any off the top of your head, but.
Those are the ones I remember, but that doesn't mean there might be others that I'm not remembering either. Yeah, did you say though just now that the guardianship task force language is still being worked on? So.
No, I think Judge Zone sent me recommended language.
Yeah, I've got that.
It's that,
Okay.
so that would be the
Right.
language at this point.
Okay.
Let's see if there's, I think those are the, I thought there was one other, somebody reached out. Well, I'll find it. Somebody did reach out just recently on something else that they wanted to have in. You were copied as well.
Yeah, that does ring a bell.
Yeah, I can't remember what, but we'll get it.
Right.
So as far as timing, probably will in the next week at least look at the language that I suggested regarding the firearms, and maybe we'll look at some of the language that we already have worked out. Because this will kind of be piecemeal, and may as well put the pieces in that we want
Sound good?
as we go. Right. All right, great. We're adjourned until 2 o'clock.